A Supreme Court decision just came down that completely blindsided legal experts on both sides of the gun debate. And here's the part nobody is talking about. This wasn't just about your Second Amendment right to own a gun. It was also about your First Amendment right to even talk about guns. And if you don't understand what just happened, you could lose both rights without even realizing it. Quick question before we continue. Are you subscribed yet? Because what I am about to break down involves two Supreme Court cases that just rewrote the rulebook for gun owners in America. And here's the shocking part. 90% of gun owners have no idea this even happened. Hit that subscribe button right now so you don't miss what comes next. This information could literally be the difference between keeping your rights and watching them disappear. So let's talk about what just went down at the highest court in the land. In June 2024, the Supreme Court handed down not one, but two landmark decisions that impact every single gun owner in America. The first case, United States v. Rahimi, was decided 8-1, and it shocked nearly everyone. The second case, NRA v. Vullo, was decided unanimously, 9-0. Taken together, these two cases fundamentally change how the government can regulate both your gun rights and your right to speak about guns. And here's why this matters. Most people think the Second Amendment is only about owning firearms. But what these cases reveal is that your First Amendment right to talk about guns, to promote gun safety, to advocate for the Second Amendment, to support gun rights organizations, is under pressure too. Let's start with the 8-1 decision everyone is talking about. United States versus Rahimi. This case involved a man named Rahimi from Texas. Rahimi was subject to a domestic violence restraining order. Under federal law, specifically 18 U.S.C. Part 922 G 8, anyone under a qualifying domestic violence restraining order is prohibited from possessing firearms. Rahimi challenged that law, arguing it violated his Second Amendment rights. And here's where things got wild. The Fifth Circuit Court of Appeals actually agreed with him. The court relied on the Supreme Court S. 2022 decision in New York State Rifle and Pistol Association versus Bruen, which held that modern gun regulations must be consistent with America's historical tradition of firearm regulation. The Fifth Circuit examined the historical record and said, "We don't see enough historical precedent for disarming people subject to restraining orders." Based on that, they ruled the law unconstitutional. But the Supreme Court reversed that decision, 8-1. Chief Justice John Roberts wrote the majority opinion. And here's the key holding. When an individual has been found by a court to pose a credible threat to the physical safety of another person, that individual may be temporarily disarmed consistent with the Second Amendment. The court looked at historical laws from the founding era, including surety laws and going armed laws, which allowed courts to temporarily disarm individuals who posed a threat to public safety. The court concluded that these historical analogs were close enough to justify modern laws disarming domestic abusers. Only Justice Clarence Thomas dissented. He argued that the majority was not faithfully applying the strict historical test required by Bruen. But 8 justices disagreed and held that this restriction passes constitutional muster. Now here's why this matters to you. The Rahimi decision clarifies something crucial. The Second Amendment is not unlimited. Even after Bruen expanded gun rights, the government can still restrict firearm possession for people who pose a credible threat to others. If you are subject to a qualifying domestic violence restraining order, you can lose your gun rights, period. But here's the detail most people are missing. The restraining order must include a specific judicial finding that you pose a credible threat to someone's physical safety. It cannot be just any restraining order. This ruling is actually narrower than many headlines suggest. It does not give the government blanket authority to disarm anyone with any restraining order. There must be a factual finding of dangerousness. Quick legal note. This is educational information, not legal advice. If you're facing a restraining order or any issue involving gun rights, you need to speak with a qualified attorney. Every case is different, and the facts matter. Do not rely on a YouTube video to make legal decisions. Always consult professional legal counsel. Now, let me tell you about the second case, because this is where your First Amendment rights come into play. And if you're finding this breakdown helpful so far, imagine what you'll learn in the next video on Money Truths, where I break down 5 words you should never say to police when they ask if you're carrying a firearm. Subscribe right now so you don't miss it. That information could save you from accidentally incriminating yourself. The second case is called National Rifle Association versus Vullo, and this one was decided unanimously, 9-0. Every single justice agreed. Here's what happened. Maria Vullo was the superintendent of the New York Department of Financial Services. After the Parkland school shooting in February 2018, Vullo allegedly used her regulatory authority to pressure banks and insurance companies to cut ties with the NRA. According to the NRA's lawsuit, Vullo met with executives from Lloyd's of London, a major insurance company. During that meeting, Vullo allegedly suggested that New York regulators would go easier on Lloyd ETS for unrelated regulatory violations if they stopped doing business with gun rights organizations, especially the NRA. Vullo also sent out guidance letters to banks and insurance companies. These letters encouraged financial institutions to consider the reputational risks of doing business with the NRA and similar gun promotion organizations. The letters urged companies to take prompt action to manage those risks and promote public health and safety. On the surface, that might sound reasonable, but here's what the NRA alleged. They argued that Vullo was using government power to coerce private companies into punishing the NRA for its pro-Second Amendment advocacy. And that's where the First Amendment comes in. The government cannot do indirectly what it is forbidden from doing directly. If the government cannot censor speech outright, it also cannot pressure third parties to silence that speech on its behalf. The district court agreed with the NRA and denied Vullo's motion to dismiss. But the Second Circuit Court of Appeals reversed, ruling that Vullo's actions were permissible government speech and legitimate law enforcement activity. The Second Circuit said the guidance letters were written in an even-handed, non-threatening tone and amounted to persuasion, not intimidation. Then the case went to the Supreme Court, and this is where everything changed. All 9 justices agreed that the NRA had stated a valid First Amendment claim. Justice Sonia Sotomayor wrote the opinion. She made one principle crystal clear. A government official cannot use the power of their office to punish or suppress disfavored expression. The court relied on a 1963 case called Bantam Books v. Sullivan. In that case, a state commission attempted to suppress publications it found objectionable by threatening distributors with potential criminal prosecution if they didn't want to stop selling certain books. The Supreme Court ruled that this violated the First Amendment. The government cannot achieve censorship through threats or intimidation, even if it never issues a direct order. Justice Sotomayor explained that the same principle applies here. The NRA plausibly alleged that Vullo threatened to wield her regulatory authority against banks and insurance companies that refused to assist her campaign to punish the NRA Gross gun promotion advocacy. According to the complaint, Vullo allegedly told Lloyd S. of London that she would ease regulatory pressure for unrelated violations if they cut ties with gun groups. That's coercion. The message was clear: help target the NRA or face stricter enforcement. The Supreme Court held that if these allegations are true, they violate the First Amendment. Now, this does not mean the NRA automatically wins the case. The lawsuit was sent back to the lower courts for further proceedings. Vullo can still argue qualified immunity. She can still attempt to show that the NRA's allegations are not factually accurate. But here's the key takeaway. The Supreme Court unanimously ruled that using government power to coerce third parties into suppressing speech is unconstitutional. So what does all of this mean for you as a gun owner? Let me break it down into practical takeaways. First, from the Rahimi decision, if you are subject to a domestic violence restraining order that includes a finding that you pose a credible threat to someone's safety, you cannot legally possess firearms. That is now settled law by an 8-1 Supreme Court decision. If you violate this law, you're committing a federal felony. You could face up to 15 years in federal prison. Do not play games with this. If you have a restraining order against you, talk to a lawyer immediately about whether you must transfer your firearms or surrender them to law enforcement. Do not take chances with federal gun charges. Second, understand that the Second Amendment has limits, even after Bruen. The court has made clear that individuals deemed dangerous can be temporarily disarmed. The justices are looking for historical analogs, but they are willing to accept regulations that are relevantly similar, not identical, to historical laws. If you are in a situation where you may be considered a threat to public safety, your gun rights can be restricted. And here's a reality check. Only 12% of people watching this video are subscribed to Money Truths. That means 88% are missing critical updates about their rights. Don't be in that 88%. Hit the subscribe button so you never miss a video that could protect your freedoms. Now here's the third takeaway, and this one is massive. The government cannot use backdoor tactics to suppress pro-gun speech. The NRA versus Vullo decision makes this crystal clear. If government officials are using their regulatory authority to pressure private companies into deplatforming gun rights organizations or gun rights advocates, that violates the First Amendment. And the implications go far beyond the NRA. Think about banks. Think about payment processors like PayPal or Venmo. Think about insurance companies. Think about social media platforms. If government officials are pressuring these companies behind the scenes to cut off gun rights groups or gun-related businesses, that is unconstitutional. Now, proving this kind of coercion isn't easy. You must show that a government official's communications could reasonably be understood as a threat or as a coercive inducement. But the Supreme Court has now confirmed that this kind of pressure, sometimes called jawboning, can cross a constitutional line. Here's the fourth takeaway. Document everything. If you're a gun rights advocate, if you run a gun-related business, or if you're involved in Second Amendment activism, keep records of any unusual actions by banks, payment processors, or service providers. If a company suddenly cuts ties with you, ask for a written explanation. If there's any indication that government pressure played a role, that could form the basis of a constitutional claim. The fifth takeaway is understanding the difference between persuasion and coercion. The government is allowed to criticize the NRA. Government officials are allowed to oppose gun rights. They can express their opinions and attempt to persuade the public. That's protected government speech. What they cannot do is threaten adverse regulatory or enforcement action to force third parties to suppress speech they dislike. That's where persuasion ends and coercion begins. Now here's the part that should really concern you. These cases reveal how much pressure is being applied to gun rights from multiple directions. It's not just gun control legislation anymore. It's financial pressure, it's regulatory pressure, it's social pressure. The strategy has shifted. If guns can't be banned outright, the gun industry and gun rights organizations can be strangled by cutting off access to banking, insurance, and essential services. Some people call this Operation Choke Point 2.0, but thanks to NRA versus Vullo, we now have Supreme Court precedent stating that this kind of backdoor censorship is unconstitutional. This is a significant win for both the First Amendment and the Second Amendment. But the fight isn't over. This case now returns to the lower courts. Similar lawsuits will follow, and gun owners need to remain vigilant. The legal landscape could change dramatically over the next 12 months. Subscribe to Money Truths now, because the next video breaks down exactly what you need to do if you are ever targeted by these tactics. Don't wait until it's too late. So let's bring this together. The Supreme Court has now spoken on two major cases affecting gun rights. In Rahimi, the court ruled that individuals subject to qualifying domestic violence restraining orders may be disarmed. That's an 8-1 decision. This is a limitation on the Second Amendment, but it's a narrow one. It applies only when a court finds a credible threat. In NRA versus Vullo, the court ruled unanimously that government officials cannot use coercion to suppress pro-gun speech. They cannot threaten third parties to cut off gun rights organizations. That violates the First Amendment. Together, these decisions make one thing clear. Gun rights are strong, but they are not unlimited. The government can regulate firearms in certain situations, especially when individuals are deemed dangerous. But the government cannot use its power to silence pro-gun advocacy. Your right to speak about guns, to promote the Second Amendment, and to operate gun rights organizations is constitutionally protected. Any official who tries to suppress that speech through backdoor pressure tactics is violating the Constitution. Here's what you need to do right now. First, if you are subject to any restraining order, talk to a lawyer immediately about your gun rights. Do not guess. Do not assume. Get professional legal advice. Second, stay informed. Gun rights law is changing rapidly, and you need to know what's happening as it unfolds. Third, support organizations that are fighting these battles in court. The NRA, the Second Amendment Foundation, and Gun Owners of America. These groups are on the front lines defending your rights. Fourth, document any unusual treatment you receive from banks, payment processors, insurance companies, or other service providers, especially if you are involved in the gun industry or gun rights advocacy. Now let me be clear. I spend hours every week researching court decisions, reading legal briefs, and breaking down complex gun law so you don't have to. The least you can do is hit the subscribe button on Money Truths so you never miss an update that could protect your rights. Because here's what's at stake. We're living in a time when gun rights are under pressure from every direction. Direct legislation, regulatory pressure, financial deplatforming, social stigma. Opponents of the Second Amendment are using every tool available. But gun owners have tools too. We have the Constitution. We have skilled attorneys. We have favorable court precedent. And we have decisions like Rahimi and Vullo that clearly define where the legal lines are. But none of that matters if you don't understand those lines. You need to know your rights. You need to understand the limits. And you need to be prepared to defend both. That's what Money Truths is about. Delivering accurate, up-to-date, no-nonsense information about gun law so you can protect yourself and your family. Let's wrap this up. Two major Supreme Court decisions just reshaped gun rights in America. Rahimi, decided 8-1, confirms that individuals subject to qualifying domestic violence restraining orders can be disarmed. NRA via Vullo, decided 9-0, confirms that the government cannot coerce third parties into suppressing pro-gun speech. Together, these cases define the current legal framework for gun rights in the United States. Know your rights. Know the limits. Stay informed. And for God's sake, subscribe to Money Truths because more cases are coming, more legal battles are brewing, and you need to be ready. Thanks for watching. I'll see you in the next one.